The Judicial Murder of Mary E. Surratt, by David Miller DeWitt. This is a LibriVox recording. All LibriVox recordings are in the public domain. Part I. The Murder. Chapter IV. Arguments for the Defense. The testimony for the several defenses of the 8 accused closed on the 7th of June, and the testimony in rebuttal ended on the 14th, with the evidence of the physicians on the sanity of Payne. Thereupon, General Ewing endeavored to extract from the Judge Advocate an answer to the two following questions: First, whether his clients were on trial for but one crime, viz., conspiracy, or 4 crimes, viz., conspiracy, murder, attempt at murder, lying in wait; and second, by what statute or code of laws the crimes of traitorously murdering, or traitorously assaulting with intent to kill, or traitorously lying in wait were defined, and what was the punishment affixed. The Judge Advocate's reply to the first question was in substance that all the accused were charged with conspiring to assassinate the President and the other members of the government named, and further with having executed that conspiracy so far as the assassination of the President and the assault on the Secretary of State were concerned, and to have attempted its execution so far as concerns the lying in wait and other matters. Assistant Judge Advocate Bingham added: The act of any one of the parties to a conspiracy in its execution is the act of every party to that conspiracy, and therefore the charge and specification that the President was murdered in pursuance of it by the hand of Booth is a direct and unequivocal charge that he was murdered by every one of the parties to this conspiracy, naming the defendants by name. Mr. Ewing: I understand, but I renew my inquiry whether these persons are charged with the crime of conspiracy alone, and that these acts of murdering, assaulting, and lying in wait were merely acts done in execution of that conspiracy. Mr. Bingham, interrupting: and not crimes. Mr. Ewing: on whether they are charged with 4 distinct crimes in this one charge. Mr. Bingham: where parties are indicted for a conspiracy and the execution thereof, it is but one crime at the common law, and that as many overt acts in the execution of the conspiracy as they are guilty of may be laid in the same count. Mr. Ewing: it is then, I understand, one crime with which they are charged. Mr. Bingham: one crime all round, with various parts performed. Mr. Ewing: the crime of conspiracy. Mr. Bingham: it is the crime of murder as well. It is not simply conspiring, but executing the conspiracy treasonably and in aid of the rebellion. Mr. Ewing: I should like an answer to my question, if it is to be given. How many crimes are my clients charged with, and being tried for, I cannot tell. Mr. Bingham: we have told you, it is all one transaction. General Ewing, not being able to get an answer intelligible to himself to the first question, then respectfully asked an answer to the second, by what code or statute the crime was defined and the punishment provided. The Judge Advocate: I think the common law of war will reach that case. This is a crime which has been committed in the midst of a great civil war, in the capital of the country, in the camp of the commander in chief of our armies, and if the common law of war cannot be enforced against criminals of that character, then I think such a code is in vain in the world. Mr. Ewing: do you base it then only on the law of nations? The Judge Advocate: the common law of war. Mr. Ewing: is that all the answer to the question? The Judge Advocate: it is the one I regard as perfectly appropriate to give. Mr. Ewing: I am as much in the dark now as to that as I was in reference to the other inquiry. It is significant that the ready Special Judge Advocate rendered no aid to his colleague on the latter branch of the inquiry. According to the theory of the prosecution, then, Mary E. Surratt was tried as a co-conspirator of Jefferson Davis and 7 of his agents, of the 7 men tried with her, and of Booth and her own son, for the crime of traitorous conspiracy to murder the President, Vice President, Secretary of State, and Lieutenant General of the United States, and for the following crimes committed in pursuance thereof: 1. Assassination of the President with Booth. 2. Attempt to murder the Secretary of State, his 2 sons, and 2 attendants (5 crimes instead of 1) with Payne. 7. Lying in wait to kill the Vice President with Atzerott. 8. Lying in wait to kill the Lieutenant General with O'Laughlin. 8 separate species of crimes beside the generic one of traitorous conspiracy. And she, a citizen, a non-combatant, a woman, was tried on this ninefold omnibus charge jointly with 7 men under the common law of war. On the 16th of June, Friday, Mr. Clampett read the argument of Reverdy Johnson against the jurisdiction of the Commission, one of the most cogent and convincing ever delivered in a court of justice. The Supreme Court of the United States, subsequently, December, 1866, in deciding the Milligan case, did but little more than reiterate the propositions maintained by this great lawyer. He opened his address by reminding the court that the question of their jurisdiction to try and sentence the accused was for the court alone to decide, and that no mandate of the President, if in fact and in law the Constitution did not tolerate such tribunals in such cases, could protect any member of the Commission from the consequences of his illegal acts. He then advanced and proved the following propositions: that none but military offenses are subject to the jurisdiction of military courts, and that the offenders, when they commit such offenses, must be subject to military jurisdiction. In other words, they must belong to the Army or Navy. That the President himself had no right to constitute military courts of his own motion, but that such power must first be exercised by Congress under the constitutional grant to that body to make rules for the government and regulation of the land and naval forces. That by the 5th and 6th Amendments of the Constitution, every person, except those belonging to the land or naval forces, or to the militia in active service in time of war, and being such, committing a military or naval crime, is guaranteed an investigation by a grand jury, as a preliminary to trial, and a speedy and public trial by an impartial jury. He then took up and examined the grounds on which the jurisdiction of the Commission was sought to be maintained, calling the court's attention to the constitutional provision that, if the institution of such commission was an incident to the war power, that power was lodged exclusively in Congress and not at all in the President, and therefore Congress only could authorize such tribunals. He showed that, neither by the Articles of War nor by the 2 acts relied on passed during the rebellion, had Congress ever authorized any such tribunal, and that a military commission like the present and under present circumstances is not to be found sanctioned, or the most remotely recognized, or even alluded to, by any writer on military law in England or the United States, or in any legislation of either country. And in this connection he pronounced the suggestion that the civil courts and juries of the District of Columbia could not safely be relied upon for the trial of these cases, an unjust reflection upon the judges, upon the people, upon the marshal, an appointee of the President, by whom the juries were summoned, and upon our civil institutions themselves. And he closed his remarks upon this branch of his subject by saying that the foregoing suggestion, upon another ground, is equally without force. It rests on the idea that the guilty only are ever brought to trial, that the only object of the Constitution and the laws in this regard is to afford the means to establish alleged guilt, that accusation, however made, is to be esteemed prima facie evidence of guilt, and that the Executive should be armed, without other restriction than his own discretion, with all the appliances deemed by him necessary to make the presumption from such evidence conclusive. Never was there a more dangerous theory. The peril to the citizen from a prosecution so conducted, as illustrated in all history, is so great that the very elementary principles of constitutional liberty, the spirit and letter of the Constitution itself, repudiated it. After depicting the peril to the rights of the citizen of confiding to the option of the Executive the power of substituting a secret for a public tribunal for the trial of offenses, he established the following propositions: that the creation of a court is an exclusively legislative function; that constitutional guarantees are designed for times of war as well as times of peace; that the power to suspend the writ of habeas corpus carries with it only the temporary suspension of the right to inquire into the cause of the arrest, and does not extend in any way over the other rights of the accused. The distinguished advocate then further maintained that, conceding the Articles of War provide for a military court like this, yet the offense charged in the present case being nothing less than treason, could not, under the provision of the Constitution regulating the trial of treason, be tried by a military commission. and also that under the Articles of War, persons who were not and never had been in the army were not subject to military law. And in order to illustrate this branch of his argument as forcibly as possible, passing in review the guaranteed and historic rights of accused persons on trials before civil courts, he arrayed the open and flagrant violations of these rights which had been permitted by the Commission on the present trial. First, in the character of the pleadings, which for indefiniteness and duplicity would not have been tolerated by any civil tribunal. Second, as to the rules of evidence, which, according to the Judge Advocate, allowed proof of separate and distinct offences alleged to have been committed, not only by the parties on trial, but by other persons, and which the accused, however innocent, could not be supposed able to meet. Third, he quoted Lord Holt, to show that in a civil court these parties could not have been legally fettered during their trial. Referring to the row of miserable beings weighed down with shackles as they had entered the court room, as they confronted their epauletted judges, and as they departed to their solitary cells day by day for more than a month, he repeated the words of the great jurist, then 200 years old. Hearing the clanking of chains, though no complaint was made to him, he said, "I should like to know why the prisoner is brought in ironed. Let them be instantly knocked off. When prisoners are tried they should stand at their ease." Then, characterizing the claim that martial law prevailed in the District of Columbia, therefore warranted the Commission, as alike indefensible and dangerous, and at the same time irrelevant because martial law had never been proclaimed, and the civil courts were in the full and undisturbed exercise of all their functions, the counsel drove this point home as follows: "We learn, and the fact is doubtless true, that one of the parties, the very chief of the alleged conspiracy, has been indicted and is about to be tried before one of these courts. If he, the alleged head and front of the conspiracy, is to be and can be so tried, upon what ground of right, or fairness, or of policy, can the parties who are charged to have been his mere instruments be deprived of the same mode of trial?" At the close of his speech he recurs to the warning that the President's command can furnish no justification to the members of the tribunal. If their function were only to act as aids to the President to enable him to discharge his prerogative of punishment, and is to that legal extent, then it is only so because the President might have dispensed with the court altogether and ordered the punishment of the culprits without any formal trial. No, he warned them, in the most courtly and courteous manner, they could not shield themselves behind the President. Responsibility to personal danger can never alarm soldiers who have faced death on the battlefield. But there is a responsibility that every gentleman, be he soldier or citizen, will constantly hold before him and make him ponder: responsibility to the Constitution and laws of his country, and an intelligent public opinion, and prevent his doing anything knowingly that can justly subject him to the censure of either. I have said that your responsibility is great. If the Commission under which you act is void and confers no authority, whatever you may do may involve the most serious personal liability. He then cited the case of Governor Wall, hung in London in 1802 for murder. A soldier under his government in the island of Goree having been whipped to death by sentence of a regimental court martial 20 years before. In that instance, want of jurisdiction in the court martial was held to be fatal to its judgment as a defense for the death that ensued under it. In this, if the Commission has no jurisdiction, its judgment for the same reason will be of no avail either to judges, Secretary of War, or President, if either shall be called to a responsibility for what may be done under it. The learned counsel then added: "The opinion I have endeavored to maintain is believed to be the almost unanimous opinion of the profession, and certainly is of every judge or court who has expressed any." And he cited the then recent charge of Judge Bond to the grand jury at Baltimore, in which the judge declared in reference to such military commissions as the present, that "such persons exercising such unlawful jurisdiction are liable to indictment by you as well as responsible in civil actions to the parties." And he quoted to the court that portion of the charge of Judge Rufus W. Peckham to a grand jury in New York City, delivered during the progress of this very trial, wherein the right of a military commission to try was denied. A great crime has lately been committed that has shocked the civilized world. Every right-minded man desires the punishment of the criminals, but he desires that punishment to be administered according to law, and through the judicial tribunals of the country. No Star Chamber court, no secret inquisition, in this 19th century, can ever be made acceptable to the American mind. Grave doubts, to say the least, exist in the minds of intelligent men as to the constitutional right of the military commission at Washington to sit in judgment upon the prisoners now on trial for their lives before that tribunal. Thoughtful men feel aggrieved that such a commission should be established in this free country, when the war is over, and when the common law courts are open and accessible to administer justice according to law without fear or favor. The unanimity with which the leading press of our land has condemned this mode of trial ought to be gratifying to every patriot. On the 23d, General Ewing, too, assailed the jurisdiction of the court in a short but powerful speech, from which are taken the following extracts: The jurisdiction of the Commission has to be sought o'er the Constitution, and against its express prohibition. It is, therefore, at least of doubtful validity. If that jurisdiction do not exist, if the doubt be resolved against it by our judicial tribunals, when the law shall again speak, the form of trial by this unauthorized commission cannot be pleaded in justification of the seizure of property or the arrest of persons, much less the infliction of the death penalty. In that event, however fully the recorded evidence may sustain your findings, however moderate may seem your sentences, however favorable to the accused your rulings on the evidence, your sentence will be held in law no better than the rulings of Judge Lynch's court in the administration of Lynch law. Our judicial tribunals at some future day will be again in the full exercise of their constitutional powers, and may think, as a large proportion of the legal profession think now, that your jurisdiction in these cases is an unwarranted assumption, and they may treat the judgment which you pronounce and the sentence you cause to be executed as your own unauthorized acts. Conviction may be easier and more certain in this military commission than in our constitutional courts. Inexperienced as most of you are in judicial investigation, you can admit evidence which the courts would reject, and reject what they would admit. And you may convict and sentence on evidence which those courts would hold to be wholly insufficient. Means, too, may be resorted to by detectives acting under promise or hope of reward, and operating on the fears or the cupidity of witnesses, to obtain and introduce evidence which cannot be detected and exposed in this military trial, but could be readily in the free but guarded course of investigation before our regular judicial tribunals. The Judge Advocate, with whom chiefly rests the fate of these citizens, is learned in the law, but from his position he cannot be an impartial judge, unless he be more than a man. He is the prosecutor in the most extended sense of the word. As in duty bound, before this court was called, he received the reports of detectives, pre-examined the witnesses, prepared and officially signed the charges, and, as principal counsel for the government, controlled on the trial the presentation, admission, and rejection of evidence. In our courts of law, a lawyer who has heard his client's story, if transferred from the bar to the bench, may not sit in the trial of the cause, lest the ermine be sullied through the partiality of counsel. This is no mere theoretical objection, for the union of prosecutor and judge works practical injustice to the accused. The Judge Advocate controls the admission and rejection of evidence, knows what will aid and what will injure the case of the prosecution, and inclines favorably to the one and unfavorably to the other. The defense is met with a bias of feeling and opinion on the part of the judge who controls the proceedings of the court, and on whom, in great measure, the fate of the accused depends, which morals and law alike reject. Whatsoever else may be pleaded in excuse or palliation of the acts of the Commission, it can never be said that its members were driven on by an overpowering sense of their duty as soldiers, in blind ignorance of the Constitution and the law. Each and every officer was made fully aware of his awful responsibility, and apprised of the precarious footing of his authority. End of chapter 4. The Judicial Murder of Marie Surratt, by David Miller DeWitt. This is a LibriVox recording. All LibriVox recordings are in the public domain. Part 1. The Murder. Chapter 5. Charge of Judge Bingham. From the 16th to the 27th of June, the time was consumed by the summing up of the several counsel for the prisoners on the facts disclosed by the evidence, and on the last mentioned day and the succeeding one, Special Judge Advocate Bingham delivered his address in answer to all the foregoing pleas, both as to the jurisdiction of the court and also as to the merits of the case. This long, carefully prepared and yet impassioned speech may be fairly considered as embodying the very proof charge of the prosecution. Indeed, under the rules of military procedure, it occupies the place and performs the functions of the judge's charge in the common law courts. As such, it deserves a closer analysis and a more extended examination than can be given to it here. The briefest and most cursory review, however, will suffice to show its tone and temper. After a solemn asseveration of his desire to be just to the accused, and a warning to the court that a wrongful and illegal conviction or a wrongful and illegal acquittal would impair somewhat the security of every man's life and shake the stability of the Republic, the learned advocate specifically declares that the charge is not simply the crime of murdering a human being, but a combination of atrocities, committed as charged upon the record, in pursuance of a treasonable conspiracy entered into by the accused with one John Wilkes Booth and John H. Surratt, upon the instigation of Jefferson Davis, Jacob Thompson, George N. Sanders, and others, with intent thereby to aid the existing rebellion and subvert the Constitution and laws of the United States. A denunciation of the rebellion as itself simply a criminal conspiracy and a gigantic assassination, the following glowing period, now that their battalions of treason are broken and flying before the victorious legions of the Republic, the chief traitors in this great crime against your government secretly conspire with their hired confederates to achieve by assassination what they in vain attempt by wager of battle. And the unequivocal announcement that it is for this secret conspiracy in the interest of the rebellion, formed at the instigation of the chief in that rebellion, and in pursuance of which the acts charged and specified are alleged to have been done, and with the intent laid that the accused are upon trial, finish the exordium. The Speaker then tackles the question of jurisdiction, which he remarks, by the way, as the Court has already overruled the plea, he would pass over in silence, but for the fact that a grave and elaborate argument has been made by the counsel for the accused, not only to show want of jurisdiction, but to arraign the President of the United States before the country and the world as a usurper of power over the lives and the liberties of the prisoners. He dexterously evades the force of the argument that the civil courts of the district were open when the crime was committed, by asserting that they were only open and are only open at this hour by force of the bayonet, and he claims that the President, acting by a military force, had as much right to try the co-conspirators of Booth as to pursue, capture, and kill the chief criminal himself, which, if true, leads us into the maintenance of the monstrous doctrine that the President, by a summary order, might have strung up the culprits without the interposition of any court. He then enters upon an argument to show that the Commission, from the very nature of its organization, cannot decide that it is no court, and he ridicules the idea that these 9 subordinate military officers could question the authority of their Commander in Chief. In this connection he gently rebukes Mr. Ewing for his bold statement to the Commission, "You gentlemen are no court under the Constitution," reminding him that not many months since he was a general in the service of the country, and as such in his department in the West proclaimed and enforced martial law, and asked him whether he is quite sure he will not have to answer for more of these alleged violations of the rights of citizens than any of the members of the court. He professes his high regard for General Ewing as a military commander who has made a liberal exercise of this power, and facetiously wishes to know whether he proposes, by his proclamation of the personal responsibility awaiting all such usurpations, that he himself shall be drawn and quartered. After disposing of General Ewing in this gingerly manner, he compensates himself for the slight restraint by pouring the vials of his unstinted wrath upon Reverdy Johnson, representing him as denouncing the murdered President and his successor, as making a political harangue, a partisan speech against his government and country, thereby swelling the cry of the armed legions of sedition and rebellion that but yesterday shook the heavens. He characterizes one of the most temperate and dignified of arguments as a plea in behalf of an expiring and shattered rebellion, and a fit subject for public condemnation. He calls upon the people to note that while the learned gentleman, Mr. Johnson, as a volunteer without pay, thus condemns as a usurpation the means employed so effectually to suppress this giant insurrection, the New York News, whose proprietor, Benjamin Wood, is shown by the testimony upon your record to have received from the agents of the rebellion $25,000, rushes into the lists to champion the cause of the rebellion, its aiders and abettors, by following to the letter his colleague, Mr. Johnson, and with greater plainness of speech, and a fervor intensified doubtless by the $25,000 received, and the hope of more, denounces the court as a usurpation, and threatens the members with the consequences. And he interrupts his tirade against one of the greatest men this country ever produced to burst forth with the following grandiloquent apostrophe: "Youngest born of the nations, is she not immortal by all the dread memories of the past, by that sublime and voluntary sacrifice of the present, in which the bravest and noblest of her sons have laid down their lives that she might live, giving their serene brows to the dust of the grave, and lifting their hands for the last time amidst the consuming fires of battle." After a brief defense of the secret sessions of the Commission, the learned advocate enters upon his circumstantial reply to the argument of Mr. Johnson, into which it is not worth while to follow him, as the main points of his contention have been rendered obsolete by the Supreme Court of the United States. Suffice it to say, he holds that the President of the United States has the power, of his own motion, to declare martial law in time of war over the whole United States, whether the States are within the theater of war or not, and that President Lincoln exercised this power by his proclamation of September, 1862, by virtue of which martial law prevailed over the whole North, including, of course, the District of Columbia, on the day of the assassination; and farther, that certain subsequent acts of Congress, though not in express terms, yet by fair implication, had ratified the proclamation. He contends, in consequence, that nothing can be clearer than that citizen and soldier alike, in time of civil or foreign war, are triable by military tribunals for all offenses of which they may be guilty in the interest of or in concert with the enemy; and that these provisions, therefore, of your Constitution for indictment and trial by jury in civil courts of all crimes are silent and inoperative in time of war, when the public safety requires it. Listen to this judicial expounder of constitutional law. Here is a conspiracy organized and prosecuted by armed traitors and hired assassins, receiving the moral support of thousands in every State and district, who pronounced the war for the Union a failure, and your now murdered but immortal Commander in Chief a tyrant. It is in evidence that Davis, Thompson, and others agreed and conspired with others to poison the fountains of water which supply your commercial metropolis, and thereby murder its inhabitants; to secretly deposit in the habitation of the people and in the ships in your harbor inflammable materials, and thereby destroy them by fire; to murder by the slow and consuming torture of famine your soldiers, captives in their hands; to import pestilence in infected clothes, to be distributed in your capital and camps, and thereby murder the surviving heroes and defenders of the Republic. I claim that the Constitution itself, by express terms, has declared whatever is necessary to make the prosecution of the war successful may be done, and ought to be done, and is therefore constitutionally lawful. Who will dare to say that in the time of civil war no person shall be deprived of life, liberty and property without the due process of law? This is a provision of your Constitution than which there is none more just and sacred in it. It is, however, only the law of peace, not of war. In time of war the civil tribunals of justice are wholly or partially silent, as the public safety may require. The limitations and provisions of the Constitution in favor of life, liberty and property are therefore wholly or partially suspended. He makes allusion to the recent re election of President Lincoln as ratifying any doubtful exercise of power by him. The voice of the people, thus solemnly proclaimed by the omnipotence of the ballot, ought to be accepted and will be accepted, I trust, by all men as the voice of God. He concludes his plea in favor of the jurisdiction of the Commission by declaring that for what he had uttered in its favor he will neither ask pardon nor offer apology, and by quoting Lord Brougham's speech in defense of a bill before the House of Lords empowering the Viceroy of Ireland to apprehend and detain all Irishmen suspected of conspiracy. The Special Judge Advocate then proceeds to sum up the evidence, in doing which he leaves nothing to the free agency of the Court. He first, by a review of the testimony of the Montgomerys and Conovers, proves to his own and presumably to the Court's satisfaction, that Davis, Thompson, Cleary, Tucker, Clay, Young, Harper, Booth and John H. Surratt did combine and conspire together in Canada to kill and murder Abraham Lincoln, Andrew Johnson, William H. Seward and Ulysses S. Grant. Surely no word further need be spoken to show that John Wilkes Booth was in this conspiracy, that John H. Surratt was in this conspiracy, and that Jefferson Davis and his several agents named in Canada were in this conspiracy. Whatever may be the conviction of others, my own conviction is that Jefferson Davis is as clearly proven guilty of this conspiracy as is John Wilkes Booth, by whose hand Jefferson Davis inflicted the mortal wound upon Abraham Lincoln. After such utterances as these, it is hardly necessary to state that this impartial judge declares every single person on trial, as well as John H. Surratt, guilty beyond the shadow of a doubt. That John H. Surratt, George A. Atzerodt, Mary E. Surratt, David E. Herold and Louis Payne entered into this conspiracy with Booth is so very clear upon the testimony that little time need be occupied in bringing again before the Court the evidence which establishes it. It is almost imposing upon the patience of the Court to consume time in demonstrating the fact, which none conversant with the testimony of this case can for a moment doubt, that John H. Surratt and Mary E. Surratt were as surely in the conspiracy to murder the President as was John Wilkes Booth himself. He lets out the secret that the mother is on trial as a substitute for her son, whom the Secretary of War and the Bureau of Military Justice had failed to capture, by saying, "Nothing but his conscious coward guilt could possibly induce him to absent himself from his mother as he does upon her trial." After having reiterated over and over again, with all the authority of his office, what he had for hours endeavored to enforce by all the resources of his intellect, that the guilt of these parties, both present and absent, is proved beyond any doubt whatever, and is no longer an open question, he closes by formally, and with a very cheap show of magnanimity, leaving the decision of this dread issue to the Court. End of chapter 5. The Judicial Murder of Mary E. Surratt, by David Miller DeWitt. This is a LibriVox recording. All LibriVox recordings are in the public domain. Part 1. The Murder. Chapter 6. The Verdict, Sentence, and Petition. With the loud and repeated denunciations of this elaborate and vindictive harangue, full as it was of rhetorical appeals to the members of the Commission to avenge the murder of their beloved Commander in Chief, and of repeated and most emphatic assurances of the undoubted guilt of each and every one of the prisoners, as well as of all their alleged accomplices, still ringing in the ear of the Court. The room is for the last time cleared of spectators, counsel for the prisoners, and reporters. The mournful procession of the accused marches for the last time from the dock to their solitary cells, their fetters clanking as they go, and the Commission meets to deliberate upon its verdict. But who remains in the room, meets with the Court, and participates in its secret and solemn deliberations? Who but Colonel Burnett, the officer who had so zealously conducted the preliminary examinations of the witnesses and marshaled the evidence for the prosecution? Who but Recorder Joseph Holt, the head of the Bureau of Military Justice, the left hand of Stanton as Baker was his right? Who but John A. Bingham, the special Judge Advocate, who had so mercilessly conducted the trial, assailing counsel, browbeating witnesses for the defense, declaring that all participants in the rebellion were virtually guilty of the assassination, and who had just closed his long speech, in which he had done his utmost to stir up the Commission to the highest pitch of loyalty, unreasoning passion, and insatiable desire for vengeance. Where can we look in the history of the world for a parallel to such a spectacle? A woman of refinement and education thrown together in one mass with 7 men to be tried by 9 soldiers for the crime of conspiring with Jefferson Davis, the arch enemy of every member of the tribunal, to kill, and killing, the beloved Commander in Chief of every member of the tribunal, 3 experienced criminal lawyers eagerly engaging in the task of proving her guilty, pursuing it for days and weeks with the unrelenting vigor of sleuth hounds, winding up by reiterating in the most solemn manner their overwhelming conviction of her guilt, and then all 3 being closeted with the Court to take part in making up the doom of death. And here let us pause to consider one feature of the trial and of the summing up of Judge Bingham, which has not yet been noticed, because it deserves special and prominent remark. It appeared from the testimony on the part of the prosecution unmistakably that during the fall of 1864 and the winter of 1864-5, Booth was brooding over a wild plot for the capture of the President, either on one of his drives or in the theater where the lights were to be turned off, then hurrying off the captive to Lower Maryland, thence across the Potomac, and thence to Richmond, thereby to force an exchange of prisoners, if not possibly a cessation of the war. It was a plot of the kind to emanate from the disordered brain of a young, spoiled, dissipated, and disappointed actor. During this period Booth made some trifling and miserably inadequate preparations, and endeavored to enlist some of his associates in its execution, and by his personal ascendancy over them he did in fact entangle, in a more or less vague adhesion to the plot, Arnold, O'Laughlin, Atzerodt, Payne, Herold, John H. Surratt, Lloyd, and possibly Dr. Mudd and Weichman. On the fall of Richmond and the surrender of Lee, this anyhow impracticable scheme was necessarily abandoned. Indeed, the proof showed that Arnold and O'Laughlin had deserted their leader some time before. It further appeared in the testimony that it was not until after the forced abandonment of this plot, and the desertion of most of his adherents, that Booth, plunged as he was into the depths of chagrin and despair because of the collapse of the rebellion, suddenly, as a mere afterthought, the offspring of a spirit of impotent revenge, seized upon the idea of murder, which was not in fact brought to the birth until the afternoon of the 14th, when he was first informed of the promised attendance of President Lincoln and General Grant at the theater. Now, the existence of the plot to capture, although it looked forth from the evidence steadily into their faces, the Judge Advocates bound themselves not to recognize. In the first place, such a concession would forever demolish the preconceived theory of the Secretary of War, Colonel Baker, and the Bureau of Military Justice, that the conspiracy to murder emanated from the Confederate Government through its Canadian agents, by pointing directly to another plot than the one to kill, as that in which these agents had been interested. The horrid monster of a widespread treasonable conspiracy to overthrow the Government, which had been conjured up in the imagination of the Secretary of War, and then cherished in the secret recesses of the Bureau of Military Justice, would have immediately shrunk into the comparative simple case of an assassination of the President and an attempted assassination of the Secretary of State by two worthless villains suddenly seizing opportunity by the forelock to accomplish their murderous purpose. And in the next place, the concession of such a plot as a fact would go far to establish the innocence of Mrs. Surratt, Arnold, O'Laughlin, and Mudd, as well as that of John H. Surratt, by explaining such suspicious circumstances as the frequent rendezvous of Booth, Payne, and others at Mrs. Surratt's house, which practice, as it was proved, ceased altogether on the fall of Richmond, and the immediate departure of the Sun to Canada. To the Judge Advocates, if not to the Court, any evidence looking toward innocence was most distasteful and unwelcome. They were in no mood to reconcile what they considered the damning proofs of a conspiracy to kill their beloved Commander in Chief, with the innocence of the fettered culprits before them, by admitting a plot to capture, into which, nevertheless, those same proofs fitted with surprising consistency. Besides, in the eyes of Bingham and Holt, complicity in a plot to capture, although unexecuted, was proof of complicity in the plot to murder, and also of itself deserved death. In this direction, therefore, the Judge Advocates were mole-eyed. On the contrary, they hailed the slightest indication of guilt with a glow of triumph. In the direction of guilt, they were lynx-eyed. Consequently, they bent every energy to identify the plot to capture with the plot to kill. They introduced anonymous letters, dropped letters, a letter mailed nearly a month after the assassination directed to J.W.B., a letter in cipher purporting to be dated the day after the assassination, addressed to John W. Wise, signed No. 5, found floating in the waters at Morehead City, North Carolina, as late as the 1st of May. This last the most flagrant violation and cynical disregard of the law of evidence on record. They did more. They labored to keep out all reference to the plot to capture. And it was for this reason that the Judge Advocates deliberately suppressed the diary found on the body of Booth. Its contents demonstrated the existence of the plot to capture. Instead of allowing the officer who testified to the articles taken from the dead body of Booth to make a detailed statement in response to one general question as to what they were, the examining counsel shows him first the knife, then the pistols, then the belt and holster, then a file with a cork at one end, then a spur, then the carbine, then the bills of exchange, then the pocket compass, following the exhibition of every article with the interrogatory, "Did you take this from the corpse of the actor?" But no diary was exhibited or even spoken of, although, as has been mentioned, it was carried by this same officer and Colonel Baker to Secretary Stanton on the night following the capture. That these Judge Advocates had carefully searched through the diary for items they could use against the prisoners is shown by their calling one of the proprietors of the National Intelligencer as a witness, to contradict the statement that Booth had left a written article, setting forth the reasons for his crime, for publication in that paper, a statement found only in the diary, whose very existence they kept secret. Therefore, when Judge Bingham came to review the evidence, he utterly refused to recognize in the testimony any such thing as a plot to capture. He shut his eyes to it, and obstinately ignored it. He scornfully swept it aside as an absurdity it would be waste of time to combat. And he twisted every circumstance which looked to a connection, however remote, with an abandoned plot to kidnap, into a proof, solid and substantial, of complicity in the plot to murder. And, therefore, when this same thorough-going advocate, with his two emulous associates, proceeded in secret conclave with the members of the Commission to go over the testimony for the purpose of making up their verdict and sentence, he summarily stifled any hint as to the possibility of a plot to capture. He banished from the minds of the Court, if they ever entertained such a purpose, any attempt to reconcile the circumstantial evidence with the existence of such a plot. And, besides, he held it up to the condemnation of those military men as equally heinous and as deserving the same punishment as the actual assassination. Thus the presence of these prosecutors during the deliberations of the Court must have exerted a deadly influence, if any influence were necessary, against the prisoners, and benumbed any impartiality and freedom of judgment which might otherwise have lodged in the members of the Commission. The Commission, with its 3 attending prosecuting officers, held 2 secret sessions, Thursday and Friday, the 29th and 30th of June. On the first day from 10 o'clock in the morning until 6 o'clock in the evening; on the second day, probably, during the morning only. The record of the proceedings is meagre, but contains enough to show the lines of the discussion which, in such an unexpected manner through one whole day, prolonged the deliberations of a tribunal organized solely to obey the predetermination of a higher power, and even made necessary an adjournment overnight. There was no difficulty with the verdicts, except in the case of Spangler, over the degree of whose guilt a majority of the Commission presumed for the first time to differ with the Judge Advocates. They would unite in a conviction of the crime of assisting Booth to escape from the theater with knowledge of the assassination, but they would go no farther. They would not find him a participant in the traitorous conspiracy. This poor fellow, as we can see now, was clearly innocent of the main charge, but that was no reason, then, why the Commission should find him so. There was more testimony pointing to his complicity with Booth on the fatal night than there was against Arnold, or O'Laughlin, or even Mrs. Surratt, and Judge Bingham, the guardian and guide of the Court, had pronounced it conclusive and brief. The testimony of the defense, however, appears overwhelmingly convincing, and, moreover, his case was admirably managed by General Ewing. For all the rest there was no mercy in the verdict. Every one was found guilty of the charge as formulated, eliminating Spangler. That is, in the judgment of the Commission, they had, each and all, been engaged in a treasonable conspiracy with Jefferson Davis, John H. Surratt, John Wilkes Booth, and others named, to kill Abraham Lincoln, President; Andrew Johnson, Vice President; William H. Seward, Secretary of State; U.S. Grant, Lieutenant General; and that in pursuance of such conspiracy they, the prisoners, together with John H. Surratt and J. Wilkes Booth, had murdered Abraham Lincoln, assaulted with intent to kill W. H. Seward, and lain in wait with intent to kill Andrew Johnson and U.S. Grant. This was the deliberate judgment of the Commission as guided by Judge Advocates Holt, Burnett, and Bingham. With the same breath with which they pronounced the guilt of Mrs. Surratt, they pronounced also the guilt of her son, of Jefferson Davis, of Clement C. Clay, of George H. Sanders, of Beverly Tucker. And there can be no doubt that if these men had also been upon trial, they all would have been visited with the same condemnation and would have met the same doom. The Commission further found Herold, Atzerodt, Payne, and Arnold guilty of the specification as formulated, eliminating Spangler; Mrs. Surratt guilty, except that she had not harbored and concealed Arnold or O'Laughlin; Dr. Mudd guilty, except that he had not harbored or concealed Payne, John H. Surratt, O'Laughlin, Atzerodt, or Mrs. Surratt; and, strangest of all, they found O'Laughlin guilty of the specification, except that he had not lain in wait for General Grant with intent to kill him, which was the very part in the conspiracy he was charged in the specification with having undertaken. It should be recollected that in the first moments of panic succeeding the assassination, Stanton and his subordinates had included among the objects of the conspiracy, as if to complete its symmetry, the murder of the Secretary of War himself. Afterwards, probably because of the attitude of Stanton relative to the prosecution, Grant was substituted as the victim of O'Laughlin and not of Booth, Stanton's son having discovered a resemblance of the captured O'Laughlin to the mysterious visitor at his father's house during the serenade on the night of the 13th of April, when General Grant was also present. This pretty romance the testimony on behalf of O'Laughlin effectually dissipated on the trial, but the indomitable Bingham still insisted on holding the prisoner to a general complicity with the plot. In this instance, as well as in that of Spangler, there may have been some dissension between a majority of the officers and the Judge Advocates, but taken altogether, the 8 verdicts could not have cost the Commission much time. It was organized to convict, and it did convict. so that it was not until the Court, having made up its verdicts, proceeded to affix its sentences, that the three advocates, still assisting at the work of death, encountered the unforeseen difficulties which compelled a prolongation of the session. The crime or crimes of which the prisoners were all pronounced guilty, with the possible exception of Spangler's, were capital, and the Secretary of War, on the eve of the assembling of the Commission, had already denounced against such offences, not excepting Spangler's, the punishment of death. The sentence, however, under the rules governing military commissions, was wholly within the power of the Court, which, no matter what the nature of the verdict, could affix any punishment it saw fit, from a short imprisonment up to the gallows. Its twofold function was, like a jury, to find a verdict, not only, but, like the judge in a common law court, to pronounce sentence; and, unlike such a judge in pronouncing sentence, the Commission was confined within certain limits by no statute. Although the whole proceedings of the Court must be subjected to the final approval of the President, yet its members were clothed alike with the full prerogative of justice and the full prerogative of clemency. There was one limit, however. While a majority could find the verdict and prescribe every other punishment, it required 2/3 of the Commission to inflict the penalty of death. 4 officers, therefore, could block the way to the scaffold, and 5 could mitigate any sentence to any degree and for any or for no reason. The Commission must have taken up the cases for sentence in the order adopted in the formal charge. As to the first 3, Herold, Atzerodt, and Payne, there could have been no dissent or hesitation. The Commission, with hardly a moment's deliberation, must have ratified the judgment of the Judge Advocates and condemned the prisoners to be hung by the neck until dead. The sentences of death formally declare, in every instance, that 2/3 of the Commission concur therein, but as to these 3 we can scarcely be in error in stating the Court was unanimous. It was not until the cases of the next 3, O'Laughlin, Spangler, and Arnold, were reached, that symptoms of dissatisfaction with the sweeping doom of death, so confidently pronounced by Judge Bingham in his charge, first began to show themselves amongst the members of the Court. It seems that now, after having joined with the counsel in pronouncing capital punishment upon the 3 most prominent culprits, the majority could no longer whet their appetite for blood, so as to keep it up to the same fierce edge as that of the Judge Advocates. The deviations from the charge and specifications the Court had finally prescribed in the verdicts against O'Laughlin and Spangler were not thought by the prosecutors to be of such importance as to warrant a softening of the sentence. But here the loyalty of some members of the Commission began to falter, and refused to bear the strain. They had found O'Laughlin guilty of the traitorous conspiracy, and Spangler guilty of aiding Booth to escape, and Arnold guilty in the same degree as Herold, Atzerodt, and Payne. But in none of these cases could the attending advocates extort a 2/3 vote for death. In the case of Spangler, owing, it is said, to the impression made by General Ewing and the influence of General Wallace, they were compelled to allow a sentence of but 6 years' imprisonment; and in the case of the 2 others, convicted co-conspirators with Booth and Davis though they were, these prosecuting officers had to rest satisfied with but life-long imprisonment. It was too evident that 5 members of the Commission had slipped the bloody rein. 3 lives had been taken; henceforth they would stop just this side of the grave. At this point, when the Commission had sentenced to death 3 men and had just declined to sentence to death 2 more whom it had pronounced guilty of the same crime, at this point it was that the sentence of Mary E. Surratt came up for determination. Now, the crimes of which Arnold had been found guilty were both in law and in fact the same of which she had been found guilty. Even the particular allegation in the specification is the same in both cases, except some immaterial variance in the verbiage and in the names of co-conspirators. Of course, it will be presumed that the Commission had found the woman guilty without being pressed; but equally of course it will not be doubted that in determining the sentence which should follow the verdict, the question of exercising the same mercy as the Commission had just exercised in the case of a man convicted of the same crime must have arisen in the case of the woman, and the question once having arisen, the first impulse of the majority, if inclined still to mercy, must have been to exert their own unquestioned function, and, as in the other cases, mitigate the sentence themselves. They would have, originally, no motive to thrust upon the President, who was to know comparatively nothing of the evidence, the responsibility of doing that thing, which they themselves, who had heard the whole case, thought ought to be done, and which, in a parallel case, they had just done. Even if they believed the woman's crime had a deeper tinge of iniquity than either Arnold's or Mudd's, of which the respective verdicts, however, gave no hint, but that nevertheless her age and sex ought to save her from the scaffold, they need not have turned to the President for mercy on such a ground. The woman, clothed upon by her age and sex, had sat for weeks bodily before them. This very mitigation was what a majority of the Court had power to administer. The reason of the mitigation was a matter of no moment. The Court could commute for age and sex, as well as the President, and, for that matter, could state the reason for the milder penalty in the sentence itself. Therefore, it may be taken for granted that here the Judge Advocates again found that 2/3 of the Court would not concur in the infliction of the death penalty. Nay, that even a majority could not be obtained. 5 out of the 9 officers announced themselves in favor of imprisonment for life. Here, indeed, was a coil. The prosecutors were at their wits' ends, and lo! when they passed on to consider the last case, that of Dr. Mudd, the same incomprehensible reluctance to shed more blood did but add to their discomfiture. The verdict indeed had been easily obtainable, but the coveted death sentence would not follow. The whole day had been spent in these debatings. The expedient of adjourning over to the next day perhaps was now tried, and the dismayed Judge Advocates, with but 3 out of the 8 heads they had made so sure of, and their female fiend likely to slip the halter, hurry away to consult with their chief. Edwin M. Stanton, as he had presided over the whole preparatory process, so too had kept watch over the daily progress of the trial from afar. Every evening his zealous aides-de-camp made report for the day and took their orders for the morrow. After the death of Booth and the escape of John H. Surratt, the condemnation to death of the mother of the fugitive had become his one supreme aim. The condemnation of the other prisoners was to him either a matter of no doubt or was a minor affair. 3 heads of the band of assassins stood out in bloody prominence: Booth, John H. Surratt, and Payne. The first had been snatched from his clutches by a death too easy. Payne, with handcuffs and fetters and chains and ball and hood, he might be confident could not evade his proper doom. Surratt, by the aid of some inscrutable malignant power, had contrived to baffle all the efforts of his widespread and mighty machinery of military and detective police. But he had the mother, the friend of Booth, and the entertainer of Payne, and she, the relentless secretary with his accordant lackeys, had sworn should not fail to suffer in default of the self-surrender of her son. She, moreover, was to be made an example and a warning to the women of the South, who, in the judgment of these 3 patterns of heroism, had unsexed themselves by cherishing and cheering fathers, brothers, husbands, and sons on the tented field. In the conclave which Stanton and his 2 coadjutors held, either during the recesses of the prolonged session of the first day, or most likely during the night of the adjournment, it was resolved that if the manly reluctance of 5 soldiers to doom a woman to the scaffold could be overcome in no other way, to employ as a last resort the suggestion that the Court formally condemn her to death, and then, as a compromise, the soft-hearted 5 petition the President to commute. The 3 plotters, trusting to the chances of the future, with the petition in their custody, and the President under their dominion, to render ineffectual this forced concession to what they scorned as a weak sentimentalism. This suggestion of what was in truth a most extraordinary device, a petition to the President to do what the Court could do itself, could not have emanated from the merciful majority of the Court, which subsequently did sign the fatal document. They, at least, were sincere, and, if let alone, would have proceeded immediately to embody their own clemency in a formal sentence, as they had done with O'Laughlin and Arnold, and as they were about to do with Mudd. Had there been but one, or two, or three dissidents, so that they were powerless in the face of two-thirds of the Commission, or even had there been four, a number sufficient to block a death sentence, but not sufficient to dictate the action of the Court, then, indeed, recourse to the clemency of the Executive might have been a natural proceeding. But a clear majority had no need to look elsewhere for a power of commutation which they themselves possessed in full vigor, and which, in all probability, after the first three death penalties, they had determined to apply in every one of the other cases. Neither could the suggestion have been made by one of the minority, because none of them signed the petition to the last. The four must have been steadfast and uncompromising for blood, a quarter which, on the one hand, was possessed by an overmastering, revengeful passion, as this was required to point the five officers to a seeming source of mercy to which they might appeal, and thus avoid the exercise of their own prerogative in an antagonism to their four brethren, and, on the other hand, harbored some secret knowledge or malign intent that the petition would or should be, in fact, an empty form. From a quarter, in short, where the desire for the condemnation to death of Mrs. Surratt was all controlling, and where the condition of the President was well known. They, who suggested the death sentence and the petition as a substitute for the milder penalty, were surely all on the side of death, and hoped, if they did not believe, that the prayer of the petition would be of no avail, else they would not have adopted such a circuitous method to do what the five officers could immediately have accomplished themselves. In one word, the contrivers of the divisive petition were not those who desired to save the bare life of the convicted she conspirator, but those who would be satisfied with nothing less than her death on the scaffold. The suggestion was wholly sinister and malevolent. On the other hand, the majority of the Court did really desire that her punishment should not exceed that of Arnold, O'Laughlin, and Mudd, and they certainly would never have had recourse to a petition to the President, had they not been cheated into believing that that method of proceeding was likely to effectuate what they had full power to do. Never would these five soldiers, or any two of them, have given their voices for the death of this woman, had they dreamed for a moment that their signing of the petition was, and was meant to be, but a farce. They would not have played such a ghastly trick under the shadow of the gibbet. Accordingly, when the Commission reassembled, either after recess or adjournment, the reinvigorated councilors immediately unfolded their plan. We can almost hear their voices, in that upper room of the old penitentiary, as they alternately urge on the Court. Holt, making a merit of yielding in the cases of Spangler, of O'Laughlin, of Arnold, and of Mudd, denounces the universal disloyalty of the women of the South, and pleads the necessity of an example. Bingham, holding up both mother and son as equally deep-dyed in blood with Booth and Payne, both insinuates and threatens at the same time, that if tenderness, forsooth, is to be shown because of the age and sex of such a she-assassin, then, for the sake of the blood of their murdered commander-in-chief, do not his own soldiers show it, but let his successor take the fearful responsibility. One of the five gives way, and now there is a majority for death. One more appeal. The life of the woman trembles in the balance. Once more to the breach. The supreme reserve is at last brought forward, an argument much in use which judge advocates in cases of refractory courts martial, as a last resort, that the President will not allow a hair of her head to be harmed, but that terror is necessary in this instance, to force the son to quit his hiding place. The life of the mother must be the bait held out to catch the unsurrendering son. We will hang him, and then free the woman's neck. Another vote comes over. Two-thirds at last concur, and her doom is sealed. They sentence Mary E. Surratt to be hanged by the neck until she be dead. Judge Bingham sits down and embodies the memorable "suggestion" in writing as follows. It is without address. The undersigned members of the Military Commission detailed to try Mary E. Surratt and others for the conspiracy and the murder of Abraham Lincoln, late President of the United States, etc., respectfully pray the President, in consideration of the sex and age of the said Mary E. Surratt, if he can, upon all the facts in the case, find it consistent with his sense of duty to the country, to commute the sentence of death which the court have been constrained to pronounce to imprisonment in the penitentiary for life. Respectfully submitted. General Ekin copies it on a half sheet of legal cap paper, and the 5 officers, viz., Generals Hunter, Kautz, Foster, and Ekin, and Colonel Tompkins, sign the copy. General Ekin keeping the draft of Bingham as a memento of so gentle an executioner. The Commission then proceeds to the next and last case, and again exercising its prerogative of clemency, sentences Dr. Mudd to imprisonment for life. It is now Friday noon. The result of the 2 days' secret session, consisting of a succinct statement of the verdict and sentence in every case, in the foregoing order, is redacted into a record. The presiding officer signs, and the recorder countersigns it. It is placed in the hands of the Judge Advocate, together with the petition to the President. There is an adjournment without day. The members disperse, and the work of the Military Commission is over. End of chapter 6. The Judicial Murder of Mary E. Surratt, by David Miller DeWitt. This is a LibriVox recording. All LibriVox recordings are in the public domain. Part 1. The Murder. Chapter 7. The Death Warrant and the Execution. From Friday afternoon, the 30th of June, through Saturday, Sunday, Monday, and Tuesday, the first 4 days of July, the record of the findings and sentences remained under the seal of sworn secrecy in the custody of the Judge Advocate General. To consummate the work of the Commission, the signature of the President to a warrant approving its action and directing the execution of its judgment was necessary. But during this interval, as it was given out from the White House, President Johnson was too ill to attend to public business. In the meantime, the city, and even the whole country to its very borders, were agitated by the question, what is to be the fate of Mrs. Surratt? The doom of the male culprits was for the moment forgotten in the intense anxiety over hers. Despite the 7-fold seal of secrecy which covered the proceedings of the secret sessions, whispers of a recommendation of mercy filled the air. In the War Department the main source of anxiety at the same time must have been this superfluous paper, the distressing outcome of an unsuspected sentimental weakness in 5 of our chosen men. After the final adjournment of the Commission, the unobtrusive, unaddressed half sheet had been fastened to the record of the sentences by the same narrow yellow silk ribbon which held its own sheets together, and to which it now dangled as a last leaf or back. A safety valve to the misplaced chivalry of the Court, it had served its purpose, and was henceforth useless. That it should now turn itself into an implement of evil, minister to the cause of rebellion and assassination, cause our own Andy to flinch at last, and thus the she-fiend of the Bureau escape her doom, it would be treason to suffer it. Upon that resolve the triumvirate of Stanton, Holt, and Bingham had once for all determined. Indestructible, inconcealable, omnipotent, indeed must that paper be, which could thwart their united purpose. At length, on the morning of Wednesday the 5th, Preston King, who in those days was a favored guest at the White House, announced in the Judge Advocate's office that the President was so much better as to be able to sit up, and at a later hour in the day General Holt, in pursuance of an appointment, started on his solemn errand. The volumes of testimony taken before the Commission by official stenographers, daily reports of which had been furnished, he, of course, did not carry with him. In the interview that was to come there would be no time and no inclination to read over bulky rolls of examinations and cross-examinations of witnesses. From aught that appears, the President was not expected to read over the evidence, nor was it customary in such cases. It may have been the duty of the Secretary of War or the Attorney General to scrutinize the testimony, either from day to day or at the close of the trial. but all that the President was supposed to know about the merits of the case appears to have been derived from what any of his Cabinet saw fit to inform him, from what he himself casually and unofficially read, but especially and principally from what the Judge Advocate was now coming to tell him. As to the guilt of the accused, and especially of Mrs. Surratt, his mind had long ago been made up for him by his imperious War Minister, from whose despotic sway he had not as yet recovered energy enough to free himself. He was still in that brief introductory period of his presidency, which may be called his Stanton apprenticeship, still eager to make treason odious, full of threatenings to hang Davis and other Southern leaders. He had not yet awakened from the state of semi-stupefaction into which his sudden and awful elevation seems to have thrown him, and in this state he must have been extremely averse to dwelling on any of the circumstances of the assassination to which he owed his high place. The idea of clemency to any one of the band of assassins, male or female, which his War Secretary's court might convict, would have been intolerable to his imagination and sickening to his sense of security. What Andrew Johnson at this moment wanted was to push away from his mind all thoughts of the tragic end of his predecessor, and to allow retributive vengeance to take the most summary course with the least possible knowledge and trouble to himself. And this mood of the Presidential mind was well known to the Judge Advocate General as he entered the President's room. He brought with him so much of the record of the proceedings of the Commission as was necessary to the accomplishment of his errand, viz., the record of the findings and sentences, which the President was to endorse. This document consisted of a few sheets of legal cap paper fastened together at the top, written on both sides in the fashion of legal papers, i.e., beginning at the top of the first page, and on reaching the bottom, turning up the paper and writing on the back from the bottom to top. It was a document complete in itself, the written record ending on the first page of the last half sheet, thus leaving blank the remainder of that page and the whole of the obverse side, ample room for the death warrant. To this record, but forming no part of it, the petition, as we have said, had been affixed, but in such a manner as to be easily separated without mutilation. He must also have brought with him his official report of the trial, styled, "the formal brief review of the case," which was subsequently appended to the regular report of the Judge Advocate General to the Secretary of War, and transmitted to the Congress in December following, because it is addressed "to the President," is dated July 5, 1865, and is signed J. Holt. It recites the verdicts and sentences, justifies its brevity by referring to the full and extensive argument of Judge Bingham, certifies to the regularity and fairness of the proceedings, and recommends the execution of the sentences, but it makes no mention of the petition or any suggestion of mercy. The Judge Advocate could have anticipated no difficulty in obtaining the approval of the President, conscious as he was that the grounds of such approval were to be furnished to the President by himself. The approval being had, the fixing of the day of execution could cause no disagreement. His only possible source of embarrassment was the petition for commutation. But it would be strange indeed if a few apt words could not further emasculate the mild, hypothetical language in which his colleague Bingham had seen fit to clothe that paper. He found the President alone, and, as he himself says, waiting for him, very pale, as if just recovered from a severe illness. Without delay, he proceeded to discharge the duty which brought him into his presence. What took place at this confidential interview, as Holt calls it, can never be precisely known, the distinguished interlocutors having subsequently risen into unappeasable quarrel over the presence or absence of the petition, and given contradictory versions. Whatever the truth may be, it is evident that everything went smoothly at the moment. The Judge Advocate was not disappointed. No difficulty was encountered. What was done quickly and at once. The record may have been read over, but this was hardly necessary, as the bare mention of the several sentences would convey a correct summary of its contents. He may have read the brief review of the case he had prepared. As Judge Holt relates, he said to the President, frankly, as it was his official duty to do, that in his judgment the proceedings of the Court were regular, and its findings and sentences justified by the evidence, and that the sentences should be enforced. And this was what he had written in his brief review. What more could the successor of the murdered Lincoln want? His approval must have been spontaneous and immediate. As Holt says, "At that time Mr. Johnson needed no urging." Mention may have been made of the curious weakness infecting some members of our court toward the wicked woman, who, as Johnson seems to have thought, had kept the nest that hatched the egg, but only to be scouted by both Judge Advocate and President as most reprehensible and actually disloyal. Their unanimity over the salutary effect of the hanging of this one woman on the female rebels was more than fraternal, and it is probable that no more explicit mention of an actual petition was made by Judge Holt in his conversation with the President than was made in his written report to the President, dated the same day, and which he had with him at the time. The day of execution was fixed upon with the same alacrity. "Make it as soon as possible, so that the disagreeable business may be over, say the day after to morrow, Friday, the 7th." And thereupon, everything being agreed upon, Judge Holt turns over the papers to the last page of the record and spreads it upon the table, beginning a few lines below the signature of D. Hunter, President, which closes the record with the date: "Executive Mansion, July 5th, 1865. With his own hand he writes out the death warrant." As this includes the approval of the sentence, the appointment of the day and hour of execution, and the designation of the place of confinement of those condemned to imprisonment, the bottom of the page is reached before he completes his task. If he had turned up the page and continued his writing on the obverse side from the bottom down, as all the foregoing had been written, then the petition of mercy, unaddressed as it was, would have been, if still attached, directly beneath the eye of the President as he signed the death warrant. But, as now appears from the record itself, the careful Judge Advocate did not turn up the page from the bottom. On the contrary, reverting to the layman's way of writing papers, he whisks the whole record over, and continues the writing of the death warrant on the back of the last half sheet of the record from the top to the bottom. By this change of method, either throwing the petition under the leaves of the record, or if disengaged, leaving it upside down. When he has thus finished his draft, he shoves it over to the President. The President signs it with a tremulous hand. The confidential interview is at an end, and the Judge Advocate, taking up the papers, hurries out and over to the War Department. At this moment the petition disappears from view. We hear no more of it. Thrust as a convenient succedaneum into the hands of the majority of the Commission, ignored, suppressed, or slurred over when before the President, it had served its pitiful purpose. Neither the Adjutant General nor any of his clerks appeared to have noticed it, although the record must have been copied more than once in his office. It seems to have sunk suddenly into oblivion. Its very existence became the subject of dispute. It was omitted from the authorized published proceedings of the Commission. It was omitted from the annual report of the Judge Advocate. The disloyal paper must have been laid alongside the suppressed diary, there to repose unseen until the impeachment of Johnson and the trial of Surratt summoned them together into the light of day. On the morning of Thursday, the 6th day of July, the 6 days' ominous silence of the War Department is broken. An order issues from the Adjutant General's office, which, bearing date the day before, and reciting the findings and death sentences of the Commission and the death warrant of the President, commands Major General Hancock to see execution done on the 7th, between the hours of 10 and 2. This order was read to Mrs. Surratt at noon. She had all along been encouraged to hope. She herself had never been able to realize the possibility of a capital condemnation in her own case, and here suddenly was death, with violence and shame, within 24 hours. She sank down under the blow. In faltering accents, she protested that she had no hand in the murder of the President, and pleaded for a few days more time to prepare for death. During the remainder of the day and throughout the night, she was so prostrated by physical weakness and mental derangement as to necessitate medical aid to keep her alive and sane. The cries of her daughter could be heard in the still darkness outside the prison. At 5 o'clock in the morning, the mother, with the 3 condemned men, was removed to a solitary cell on the first floor, preparatory to the execution. In the meantime, when it first became known that, by the sentence of the Commission and the direction of the President, Mrs. Surratt was to die by the rope on the same scaffold with Payne, Herold, and Atzerodt within 24 hours, a chill of despairing terror froze the blood of her relatives and friends, a thrill of consternation swept over the body of the citizens, and dark misgivings disturbed even the most loyal breasts. A stream of supplicants at once set in towards the Executive Mansion. Not only friends and acquaintances of the condemned woman, but strangers, high-placed men, and women too, who were haunted by doubts of her guilt and could in some degree realize her agony. But even this expiring effort of sympathy the powers behind the President had anticipated. Apprehensive that Andrew Johnson at the last moment might yield to distressing importunities for more time, they had already taken measures that their sick man's wish to hear nothing till all was over should be scrupulously respected. Preston King and General James Lane undertook to keep the door and bar all access to the President during the dreadful interval between the promulgation of the sentence and its execution. It was rumored that they, with a congenial crew, held high revelry around their passive chief in his private apartments. Be this as it may, no supplicant, friend, acquaintance, or stranger was allowed to gain access to the President. The priests, who had attested upon her trial the good character, the piety, and the general worth of their parishioner, instinctively turned their steps to the White House to beg for clemency, or at least a respite. They were repulsed from its door. In ghastly mockery they were told to go to Judge Holt. At last the daughter of the victim made her way to the very threshold of the President's room. Frenzied with grief, she assailed the portal with her cries for admission to plead for her dying mother. She was denied admittance. In the extremity of her despair she lay down upon the steps, and in the name of God appealed to the President and to the wardens only to listen to her prayer. The grim guardians of the door held it shut in her face. Denied thus even an appeal to executive clemency, the friends of the poor woman, as a last most desperate resort, invoked the Constitution of their and her country through the historic writ of habeas corpus. On the morning of the day of the execution they found a Judge Wiley, all honor to his memory, who had the independence and courage to grant the writ. At 11:30, General Hancock appeared before the Judge and made return that, by order of the President, the habeas corpus was suspended, and therefore he did not produce the body. The order of the President, dated 10 o'clock, same morning, was annexed to the return and directed the General to proceed with the execution. No sooner had the guarantees of the Constitution been thus finally set at naught, than the cell doors were thrown open and the prisoners summoned to their doom. As the enfeebled widow raised her trembling limbs from off the coarse mattress which alone separated her body from the stone floor of her dungeon, she strove, in broken words, to assure the soldiers who had come to bind her arms behind her back and tie cords around her skirts above and below the knee, of her utter yet helpless innocence. Her confessor, who stood by her until the last, gently pointed out to her the uselessness of such appeals at such a moment, and directed her hopes towards heaven. Amid the tolling of the bells, sending a shudder through the silent population of the city, and heralded by the tramp of armed men, the death march of the doomed woman and the doomed men begins. The still breathing men and still breathing woman are clothed already in their shrouds. As she totters first along the corridor, accompanied by her priest and requiring 2 soldiers to hold her erect, the very extremity of her helplessness and woe bears witness in her favor. Even the bloody Payne, who walks next behind her, has broken through that stolid indifference to his own fate, so remarkable as to indicate insanity, to clear her from all complicity with the assassination. Herold and Atzerodt, who follow, though themselves speechless with terror, seem to wave her mute acquittal as they stumble along into the swift coming darkness. They reach the prison yard. They mount the high scaffold. They are seated in 4 chairs, facing the 4 dangling nooses, while the death warrant is once more read. Their graves, already dug, are in full sight close by. Their coffins stand by the side of the open graves. They are raised up and pushed forward upon the 2 drops, Harold and Atzerodt on one, Mrs. Surratt and Payne on the other, the half conscious woman still supported by the 2 guards. The ropes are adjusted, the hoods drawn over the face. The signal is given, the 2 drops fall. Surrounded by the unpitying soldiery, headed by the unpitying Hartranft, the woman and the men hang writhing in the agonies of an ignominious death. When pronounced dead, the bodies are cut down. They are laid out on the top of the coffins. A hurried post mortem examination is made, and then, at 4 o'clock in the afternoon, they are enclosed in the coffins and buried side by side. The soldiers depart with flourish of trumpet and beat of drum. Silence descends upon the grounds of the old arsenal, broken only by the pace of the sentinel set to guard the 4 corpses. The daughter may beg the stern Secretary to yield up the body of her murdered mother, that she may place it in consecrated ground, but she will beg in vain. And so ended the fell tragedy. And so did brave soldiers avenge the murder of their beloved Commander in Chief. Methinks their beloved Commander in Chief, could his freed spirit have found a mortal voice, would have spurned with indignant horror the savage sacrifice of a defenseless woman to appease his gentle shade. End of chapter 7. The Judicial Murder of Mary E. Surratt by David Miller DeWitt. This is a LibriVox recording. All LibriVox recordings are in the public domain. Part 1. The Murder. Chapter 8. Was it not murder? And now what shall be said as to this taking of human life? Maintaining the most rigorous allegiance to the simple unadulterated truth, what can be said? Arraigned at the bar of the common law as expounded by the precedents of centuries and confronted by plain provisions of the Constitution of the United States, which need no exposition, and yet have been luminously expounded, but one thing can be said. Had Mary E. Surratt the right guaranteed by the Constitution to a trial, singly and alone, in a regularly constituted civil court, and by a jury of the vicinage, the individuals of which she might select by challenge, both for cause, in all cases, and without cause to a certain number, before she could be legally convicted of any crime whatever, or be lawfully punished by the most trivial loss of property or the minutest injury to limb, to say nothing of the brutal crushing out of her life? That's the unevadable question which the ages put and will continue to put, and upon its precisely truthful answer depend the character and color of the acts of every person who had lot or part in the execution of this woman. On the 21st day of October, 1864, while the war was still raging, Lambden P. Milligan, a citizen of the United States and a resident of Indiana, was arraigned before a military commission convened by the commanding general of that military district at Indianapolis, on the following charges preferred against him by Henry L. Burnett, Judge Advocate of the Department of the West: 1. Conspiracy against the Government of the United States. 2. Affording aid and comfort to the rebels. 3. Inciting insurrection. 4. Disloyal practices. 5. Violation of the laws of war. There were also specifications, the substance of which was that Milligan had joined and aided a secret society, known as the Order of American Knights or Sons of Liberty, for the purpose of overthrowing the government and authorities of the United States, had communicated with the enemy, conspired to seize munitions of war in the arsenals, and to liberate prisoners, resisted and encouraged resistance to the draft, at or near Indianapolis, in Indiana, a state within the military lines of the Army of the United States, and the theater of military operations, and which had been and was constantly threatened to be invaded by the enemy. On these charges and specifications Milligan was subjected to a lengthy trial by this military commission, which finally found him guilty on all the charges and sentenced him to be hanged. The record was approved by the commanding general and then transmitted to President Lincoln, who held it long under advisement, and was so holding it when he was killed. His successor, at about the same time that he summoned the commission to try Mrs. Surratt, at length approved the findings and ordered the sentence to be executed on Friday, the 19th day of May, 1865. But this object lesson to the commission sitting at that date in the old penitentiary was intercepted. On the 10th of May, Milligan brought the record before the United States Circuit Court by a petition for his discharge, and the two judges differing upon the main question of the jurisdiction of the commission, the cause was certified under the statute to the Supreme Court of the United States, in deference to which action the President suspended the execution. This argument before that high tribunal coming on in the winter of 1865-66, a great array of counsel appeared upon both sides. David D. Field, James A. Garfield, and Jeremiah S. Black for the prisoner, and Attorney General Speed and Benjamin F. Butler for the United States. The counsel for the government followed the same line as did Judge Bingham in his argument on the conspiracy trial, the counsel for the prisoner on their side, only enlarging, emphasizing, and enforcing the arguments of Reverdy Johnson. At the close of the term, the court unanimously decided that the military commission had no jurisdiction to try Milligan, that its verdict and sentence were void, and ordered the defendant discharged. At the next term, the court handed down two opinions, one the opinion of the court read by Judge Davis, in which 4 of his colleagues concurred, and one by Chief Justice Chase, in which 3 of his colleagues concurred. The two opinions agreed that, as matter of law, the President could not of his own motion authorize such a commission, and that, as matter of fact, the Congress had not authorized such a commission, and therefore they were at one in their conclusion. But they differed in this, that whereas the majority of the court held that not even the Congress could authorize such a court, the minority, while agreeing that the Congress had not exercised such a power, were of opinion that such a power was lodged in that branch of the government. The attempt has often been made to distinguish the case of Mrs. Surratt from that of Milligan by alleging that Washington at the time of the assassination was within the theater of military operations and actually under martial law, whereas Indiana at the time of the commission of Milligan's alleged offenses was not. Now it must be admitted that at the time of the murder of President Lincoln the war had swept far away from the vicinity of the Capitol. There had been no Confederate troops near it since Early's raid in the summer of 1864, and no enemy even in Shenandoah Valley since October. It must also be admitted, and was in fact proved on the trial, that the civil courts were open and in full and unobstructed discharge of their functions. As for the reiterated affirmation of Judge Bingham that the courts were only kept open by the protection of the bayonet, that is precisely what was affirmed by General Butler in his argument before the Supreme Court to have been the fact in Indiana. None of the counsel in the Milligan case claimed that a military commission could possibly have jurisdiction to try a simple citizen in a state where there was no war or rumors of war. "We do fully agree that if at the time of these occurrences there were no military operations in Indiana, if there was no army there, if there was no necessity of armed forces there, then this commission had no jurisdiction to deal with the relator, and the question proposed may as well at once be answered in the negative." They contended as the very basis of their case that the acts of Milligan "took place in the theater of military operations, within the lines of the army, in a state which had been and then was constantly threatened with invasion." And in fact the record in so many words so stated, and the statement was uncontroverted by the relator. General Butler with great earnestness put the question, If the court takes judicial notice that the courts are open, must it not also take judicial notice how, and by whose protection, and by whose permission they were so open; that they were open because the strong arm of the military upheld them; because by that power these sons of liberty and knights of the American circle, who would have driven them away, were arrested, tried and punished? If the soldiery of the United States, by their arms, had not held the State from intestine domestic foes within, and the attacks of traitors without, had not kept the 10,000 rebel prisoners of war confined in the neighborhood from being released by these knights and men of the order of the Sons of Liberty, there would have been no courts in Indiana, no place in which the circuit judge of the United States could sit in peace to administer the laws." Moreover, the opinion of the minority judges bases their contention that Congress had the power, if it had chosen to exercise it, to authorize such a military commission, upon this very fact. "In Indiana, for example, at the time of the arrest of Milligan and his co conspirators, it is established by the papers in the record that the State was a military district, was the theater of military operations, had been actually invaded, and was constantly threatened with invasion. It appears also that a powerful secret association, composed of citizens and others, existed within the State, under military organization, conspiring against the draft, and plotting insurrection, the liberation of the prisoners of war at various depots, the seizure of the State and national arsenals, armed co operation with the enemy, and war against the national government." Not one of these circumstances, except that it was a military district, can be truthfully predicted of the District of Columbia at the time of the assassination. As for actual martial law, there was no declaration of martial law claimed for the city of Washington, other than the proclamation of the President, which applied as well to Indiana, and indeed to the whole North. We are justified, therefore, in saying that the Supreme Court of the United States, in this case of Milligan, pronounced the final condemnation of the whole proceedings of the military commission which tried and condemned Mary E. Surratt, declaring, with all the solemn face of a determination of the highest judicial tribunal known to this nation, that every one of its acts, from its creation by the President to its transmission of its record of doom to the President, was in direct contravention of the Constitution of the United States and absolutely null and void. That illustrious court, speaking by Judge David Davis, thus enunciates the law: "The Constitution of the United States is a law for rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men, at all times, and under all circumstances. No doctrine involving more pernicious consequences was ever invented by the wit of man than that any of its provisions can be suspended during any of the great exigencies of government. Such a doctrine leads directly to anarchy or despotism. From what source did the military commission derive their authority? It is not pretended that the commission was a court ordained or established by Congress. They cannot justify on the mandate of the President, because he is controlled by law, and has his appropriate sphere of duty, which is to execute, not to make the law, and there is no unwritten criminal code to which resort may be had as a source of justification. The laws and usages of war can never be applied to citizens in States which have upheld the authority of the government and where the courts are open and their processes unobstructed. And no usage of war could sanction a military trial there for any offense whatever of a citizen in civil life, in no wise connected with the military service. Congress could grant no such power, and to the honor of our national legislature be it said it has never been provoked by the state of the country even to attempt its exercise. All other persons, i.e., all other than those in the military and naval service, citizens of States where the courts are open, if charged with crime, are guaranteed the inestimable privilege of trial by jury. This privilege is a vital principle, underlying the whole administration of criminal justice. It is not held by sufferance, and cannot be frittered away on any plea of state or political necessity. It is claimed that martial law covers with its broad mantle the proceedings of this military commission. Martial law cannot arise from a threatened invasion. The necessity must be actual and present, the invasion real, such as effectually closes the courts and deposes the civil administration. Martial law can never exist where the courts are open, and in the proper and unmolested exercise of their jurisdiction. It is also confined to the locality of actual war." Had the swift process by which this unfortunate woman was hurried to the scaffold been interrupted by a stay to allow a review of the same high tribunal which rescued Milligan from the jaws of death, it cannot be doubted that in her case, as in his, the same conclusions would have been reached, viz.: First, one of the plainest constitutional provisions was therefore infringed when Mary E. Surratt was tried by a court not ordained and established by Congress, and not composed of judges appointed during good behavior. Second, another guarantee of freedom was broken when Mary E. Surratt was denied a trial by jury. That in her case, as in his, the court would have set the prisoner free. There would have been no hanging, no felon's grave, and not even an ulterior attempt at a constitutional trial. For it is remarkable that, although the military tribunal which tried Milligan pronounced him guilty of crimes deserving a traitor's death, the seeming strength of the evidence must have melted away, strangely enough, when subjected to the prospective investigation of constitutional courts, as there was not even a subsequent effort on the part of the government to call him to account. Let us add, as a final corollary to this exposition of the Constitution by the Supreme Court, the following remark: that the ground and argument employed by Attorney General Speed, in his opinion, upon the right of the President to order the trial of the alleged assassins by military commission, and by Judge Advocate Bingham in his address to that commission, involve a reductio ad absurdum, or, rather, a reductio ad monstrosum, that is, a reductio ad absurdum quia monstrosum. For that ground and that argument, invoked to uphold and sanction the trial of civilians by military commissions, necessarily and inevitably go farther, and proclaim the right of President Johnson, alone, of his own motion, and without the interposition of a formal court, whether military commission or drumhead court martial, to have commanded the immediate execution of every person whom he might believe to be guilty of participation in the assassination of his predecessor, or in the presumed attempt upon himself. The conclusion forced upon us, therefore, the one only thing to be said, is that the hanging of Mary E. Surratt was nothing less than the crime of murder. Murder. Not only in the case of the private soldiers who dragged her to the scaffold and put the rope around her neck. They at least can plead the almost irresistible force of military discipline. But murder also in the case of the Major General whose sword gave the signal for the drop to fall. General and soldiers are in the precise position, before the law, of a mob of lynchers carrying out the judgment of a lynch court. Murder, not only in the case of the one military officer who superintended the details of the execution. He, too, though with much less force, can plead that he was the mere bailiff of what he believed to be a competent court. But murder, also, on the part of the 9 military officers and the 3 advocates who tried and sentenced this woman to death. These men, in the forum of the law, stand in the precise position of any 9 policemen, steered by any 3 police attorneys in the city of New York, who should dare to try, convict, and sentence to death a citizen of that city. Murder, not only on the part of the Commission and its lawyers. They, too, might possibly plead, though with still diminishing force, that although they were warned and took the awful responsibility, still they believed in their competency. But murder, also, in the President of the United States, who appointed the court, approved its findings, and commanded the execution of its sentence. He stands before the law in the same position as though, sweeping aside all empty forms, he had seized a sword and with his own hand cut off the head of the woman, without the mockery of a trial. In our frame of government there is surely no room for such a twi-formed barbarian despot as a President having the power to pick out from the army, of which he is the commander in chief, the members of a court to try and punish with death, at his option, any one of the citizens for an abortive attempt on his own life. And it was murder, not only in the case of the President. He, too, but with scarcely audible voice, might plead the coercion of his situation, sitting as he did in the seat of the murdered Lincoln. But it was murder also in the Secretary of War, who initiated the iniquitous process, pushed on the relentless prosecution, shut his own ears and the ears of the President to all pleas for mercy, presiding like a Moloch over the scaffold, and kept the key of the charnel house, where, besides the unpitied carcasses of the reputed ruffians forced upon her in her ordeal of torture, and in the hour of death, the slaughtered lady lay mouldering in her shroud. Here, at least, the plea of mitigation exhales in a cry like that of pain: "I was mad." Weigh the extenuating circumstances in whatever scale you may. Extend as much mercy as possible to those who showed no mercy in their day of power. Still, the offense of every one and all who had hand, part, or lot in this work of death contains every element which, under the most rigorous definition of the law, makes up the crime of murder. The killing was there. The unlawful killing was there. The premeditated design to effect death was there. The belief of the perpetrators that they had a right to kill, or that they were commanded to kill by an overruling power, before a court of law avails not a whit. Ignorance of the Constitution, as well as the law, excuses no man, be he civilian or soldier, President or assassin, War Minister or Payne. Murder it essentially was, and as such it should be denounced to the present and future generations. Garrett Davis told no more than the exact truth when he declared in his place in the Senate of the United States: "There is no power in the United States in time of war or peace that can legitimately and constitutionally try a civilian who is not in the naval or military service of the United States, or in the militia of a State in the actual service of the United States, by a court martial or by a military commission. It is a usurpation, and a flagitious usurpation of power for any military court to try a civilian, and if any military court tries a civilian and sentences him to death, and he is executed under the sentence, the whole court are nothing but murderers, and they may be indicted in the State courts where such military murders are perpetrated, and if the laws were enforced firmly and impartially, every member of such a court would be convicted, sentenced, and punished as a murderer." Although the actual guilt of any of the victims constitutes no legal defense to this fearful charge, yet, as the unquestioning obedience which the soldier yields, as a matter of course, to the commands of his superior officer, must alleviate, if it do not wipe away, the guilt of the members of the Commission, in the forum of morals, so the ascertainment that the sufferers on the scaffold and in prison, in fact, deserved their doom, cannot but blunt the edge of our condemnation of the iniquity of the trial, as well as weaken our pity for the condemned and our sense of shame over the tyrannous acts of the government. A word or two, therefore, will be appropriate in respect to the sufficiency of the testimony to establish the guilt of the accused. 1. As to Arnold and O'Laughlin, it may be said in one emphatic word that there was no evidence at all against them of complicity in the plot to kill. The letter of Arnold to Booth shows, when fairly construed, that if the writer had conspired with the actor, he conspired to abduct, and also, for the time being, even that conspiracy had been abandoned. He was in Fort Monroe for the 2 weeks prior to the assassination. His confession, used on the trial against himself not only, but also against O'Laughlin, because he was mentioned in it as present at a meeting of the conspirators, was a confession only of a conspiracy to abduct, which had been given up. Condemnation of these two men was brought about by the conduct of Judge Bingham, to which we have drawn attention, in systematically shutting his eyes to the existence of any conspiracy to capture, and employing the letter and confession as proof that both these men were guilty of conspiracy to murder. 2. As to Dr. Mudd, the evidence leaves it doubtful whether or not he recognized Booth under his disguise on the night he set his broken leg, and therefore whether he may have been an accessory after the fact or not; but the testimony of the informer Weichman, by which chiefly, if not solely, the prosecution sought to implicate the doctor in the conspiracy to murder, was greatly damaged, if not completely broken down, by the proof on the part of the defense that Dr. Mudd had not been in Washington from November or December, 1864, until after the assassination. 3. As to Payne, his guilt of the assault on Seward in complicity with Booth was clear, and confessed by himself. He was but 20 years of age, of weak mind, entirely dominated by the superior intellect and will of Booth. He claimed he acted under the command of his captain. He was so stolidly indifferent during the trial as to raise suspicions of his sanity, and he repeatedly expressed his wish for the termination of the trial so that he might cease to live. 4. As to the boy Harold, it was manifest that as the mere tool and puppet of Booth he was acquainted beforehand with the design of his master to kill the President, but there is no evidence that he aided or abetted Booth in the actual assassination in any way, except to participate in his flight after he had got out of Washington. 5. As to Atzerodt, for whom there appears to have been no pity or sign of relenting, it is nevertheless a fact that the testimony to his lying in wait for Andrew Johnson is so feeble as to be almost farcical. The poor German was a coward and never went near Johnson. There is no circumstance in the evidence inconsistent with his own confession that he was in the plot to capture, knew nothing of the design to murder until 8 o'clock on the evening of the 14th, and then refused to enact the part assigned him by Booth. Indeed, it would appear as if the Commission, by a sort of proleptic vision of the future course of the President in his desperate struggle with the Congress, in grim irony actually hung Atzerodt because he did not kill Andrew Johnson. 6. And as to Mrs. Surratt, the only witnesses of importance against her are Weichman and Lloyd. Without their testimony the case for the prosecution could not stand for a moment. Weichman, a boarder and intimate of her house, the college chum of her son, and equally with him the associate of Payne; Atzerodt, Harold, and Booth, who, frightened almost to death at the outlook, was swearing under a desperate strain to clear his own skirts from the conspiracy and thus save his threatened neck. Weichman's testimony before the Commission, even at such a pass, is for some reason quite vague and indefinite, and only becomes deadly when supplemented by Lloyd's. This man Lloyd it was who, in fact, furnished the only bit of evidence directly connecting Mrs. Surratt with the crime. He testifies to 2 conversations he had with her, one on the 11th and the other on the 14th of April, when she alluded to the weapons left weeks before at the hotel at Surrattsville, owned by her and kept by Lloyd; on the 11th that the shooting irons would be wanted soon; on the 14th that they would be called for that night. Lloyd himself, however, admits, and it is otherwise clearly shown, that on the 14th he was so drunk as hardly to be able to stand up. Lloyd also was deeply implicated in the conspiracy to capture, if not to assassinate. He had aided the fugitive assassins to escape, had kept their weapons hidden in his house, and he had, for 2 days after his arrest, denied all knowledge of Booth and Harold's stopping at his hotel at midnight after the murder. He had been placed in solitary confinement and threatened with death. His nervous system, undermined by debauchery, gave way, his terrors were startling to witness and drove him well nigh mad, and at last, in a moment of distraction, he turned against Mrs. Surratt and her son. Like Weichman's, his, also, was the frenzied effort of a terror-stricken wretch to avoid impending death by pushing some one forward to take his place. Reverdy Johnson, at the close of his plea to the jurisdiction of the court, let fall the following words, no less weighty for their truth than their force: "This conclusion in regard to these witnesses must be in the minds of the court, and is certainly strongly impressed upon my own, that if the facts which they themselves state as to their connection and intimacy with Booth and Payne are true, their knowledge of the purpose to commit the crimes and their participation in them is much more satisfactorily established than the alleged knowledge and participation of Mrs. Surratt." Moreover, the testimony of both these witnesses, suborned as they were alike by their terrors and their hopes, is perfectly reconcilable with the alternative hypothesis, either that the woman in what she did was an innocent dupe of the fascinating actor, or that she was unaware of the sudden transformation of the long pending plot to capture, of which she might have been a tacit well wisher, into an extemporaneous plot to kill. Much stress was laid by Mr. Bingham on her solemn denial of any prior acquaintance with Payne when confronted with him on the night of her arrest. But it is more than probable that the non-recognition was unsimulated, because of the disguise and pitiable plight of the desperado, who had been hidden in the mud of the suburbs 3 days and 3 nights, and also because the non-recognition was shared with her by the other ladies of the house. Besides, that a woman, caught in the toils in which Booth and her own son had unwittingly involved her, under the terror of recent arrest and imminent imprisonment, should have shrunk from any acknowledgment of this midnight intruder, even to the extent of falsehood, certainly is in no wise incompatible with innocence. These are the only circumstances by which Mrs. Surratt is brought nearer than conjectural connection with the assassination, and the force of these is greatly weakened by the testimony in her defense. It is neither necessary nor relevant to this exposition to enter into a lengthy discussion upon the pros and cons of her case. Her innocence has been demonstrated in a more decisive manner by subsequent events, and stands tacitly admitted by the acts of the officers of the government. Few impartial hearers would have said then, and no impartial readers will say now, that the testimony against her is so strong as to render her innocence a mere fanciful or even an improbable hypothesis. No one can say that a jury, to a trial by which she was entitled under the Constitution, would have pronounced her guilty, and every one will admit that had her sentence been commuted to imprisonment for life, as 5 of her judges recommended, she would have been pardoned with Arnold, Spangler, and Mudd, and might have been living with her daughter to day. The circumstances of the whole tragedy warrant the assertion that, had John H. Surratt been caught, as were the other prisoners, he, and not she, would have been put upon trial. He, and not she, would have been condemned to death. He, and not she, would have died by the rope. If he was innocent, then much more was she. Mary E. Surratt, I repeat, suffered the death of shame not for any guilt of her own, but as a vicarious sacrifice for the presumed guilt of her fugitive son. Chapter 9.